Bonjour et bienvenue. Hello and welcome to Business and Human Rights, the International Advisory Opinions on Climate Change. Le Centre de recherche et d'éducation en droit de la personne de l'Université d'Ottawa, CREDP ou HREC, et l'Association internationale de droit du Canada, l'ADI Canada, sont très heureux de présenter ce premier webinaire. Entreprises et droits de la personne, les avis consultatifs internationaux sur le changement climatique. C'est le premier webinaire dans notre série de webinaires sur les entreprises et les droits de la personne. My name is Una Fitzgerald. I am president of the International Law Association of Canada and an HREC Senior Fellow. In keeping with Indigenous protocols and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let us begin by acknowledging the traditional territories of Indigenous people. We are meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters we call Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter, et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et dans nos communautés. The International Law Association of Canada, ILA Canada, is the Canadian branch of the International Law Association based in London, England, and founded in Brussels, Belgium in 1873. With over 5,000 members around the world, it's our collective objective to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. It's now my pleasure to introduce Professor Penelope Simons, Director of the Human Rights Research and Education Center. Her research is focused on the human rights implications of domestic and transnational business activity, and particularly on natural resource extraction and how best to regulate such activity to protect human rights and prevent and mitigate other harm. She also considers the intersections between transnational corporate activity, human rights, and international economic law, and her current work is on gender and resource extraction. Penelope will introduce HREC and our three wonderful speakers and will moderate this panel. Thank you.
Thank you very much, Una, and welcome everybody. Thank you very much for coming to this webinar. I'm the director, as Una said, of the Human Rights Research and Education Center, and we have a mandate to not only do research in human rights, but also to provide education. And we are excited about this series of webinars on business and human rights issues, and also to be partnering with the International Law Association, the Canadian section. So in this webinar today, we're going to be discussing the groundbreaking advisory opinions on state obligations with respect to addressing climate change that have been rendered by three international tribunals: the International Tribunal on the Law of the Sea, the International Court of Justice, and the Inter-American Court on Human Rights. Of course, the European Court of Human Rights has considered this issue in a case against Switzerland, and in May in 2025, an advisory opinion was requested of the African Court on Human and People's Rights by a coalition of lawyers, civil society organizations, on what the human rights obligations of African states are in the context of climate change. So that is a space to watch. But today we'll just be focusing on these three advisory opinions and drawing out the implications of these advisory opinions for states and business in the context of business activities. What do they mean for business and human rights? So I'll introduce our three speakers now. First of all, we have Professor Sarah Seck, who is a full professor at the Schulich School of Law and director of the Marine and Environmental Law Institute at Dalhousie University. She's a global leader in business and human rights and the environment, and including climate change. And her research spans many areas of law, including human rights, environment, climate change issues, resource extraction, intersectional and decolonial approaches to rights, as well as relational theories. Her more recent work focuses on oceans law, and human rights-based approaches to addressing the plastics value chain and climate change responsibility. And she is currently the co-editor of the Ocean Yearbook. She's going to be talking about the advisory opinion of the International Tribunal for the Law of the Sea. Our second speaker is Salvador Herencia Carrasco, who's a part-time professor in the Department of Civil Law at the Faculty of Law and a member of the Human Rights Research and Education Center. He's a PhD candidate also at the Faculty of Law, University of Ottawa. He previously worked as a legal advisor for the Andean Commission of Jurists. He was senior jurisdictional counsel to the Constitutional Court of Peru and chief human rights legal advisor to the Peruvian Department of Justice and Human Rights. And he's an expert on the Inter-American human rights system and is going to be speaking about the advisory opinion of the Inter-American Court on Human Rights. And our third speaker, Chiara Macchi, is an assistant professor of law, coordinator of the education at the Wageningen University, the Netherlands. Sorry about pronouncing that like that, because you can perhaps correct me, Chiara, later. She's a member of the law group there, assistant editor of transnational environmental law, and a member of the Center of Excellence on Corporate Sustainability and Human Rights Law of the university. And she's the author of the monograph Business, Human Rights, and the Environment, the Evolving Agenda. She's published widely on corporate responsibility under international law, climate change due diligence, extraterritorial human rights obligations, human rights due diligence legislation, and the human rights responsibilities of investors, and is one of the leading experts on climate change and business and human rights. So welcome to you all, and thank you for joining us. So we're going to start by talking about the provenance of these advisory opinions. So how did these cases come before the respective courts, and what were the questions that were put to the courts? So Sarah, why don't we start with you? Can you tell us about the genesis of the advisory opinion by the International Tribunal of the Law of the Sea?
Great. Thanks very much, Penelope and Una, and thanks for including me in this panel. And also thanks for including this particular advisory opinion, which, as we will see, does not explicitly engage with human rights, but yet is nevertheless very relevant, I think, to the business and human rights context. So the case is called case number 31, request for an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law, also known as COSIS. The decision dates from the 21st of May, 2024. It was a unanimous opinion of 21 judges with several accompanying declarations. Now, the request for the advisory opinion was submitted by COSIS by letter in December of 2022. And COSIS was created pursuant to an agreement in October 2021 by Antigua and Barbuda and Tuvalu and other countries, small island states, acceded to this agreement at a later date. COSIS was created specifically to enable small island states to collectively take action to respond to urgent threats relating to climate through international law. And the agreement explicitly authorizes COSIS to request an advisory opinion or multiple advisory opinions from the International Tribunal of the Law of the Sea. Now, that is in accordance with Article 138 of the ILO's Rules of Procedure, in that for ILOs to have jurisdiction, the request must have been provided as a result of an international agreement. So the purpose of COSIS is described as to promote and contribute to the definition, implementation, and progressive development of rules and principles of international law concerning climate change, including, but not limited to, the obligations of states relating to the protection and preservation of the marine environment. And so the specific questions that were put before the court are, what are the specific obligations of state parties to the UN Convention on the Law of the Sea under Part 12? A, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely to result from climate change, including through ocean warming and sea level rise and ocean acidification, which are caused by anthropogenic GHG emissions into the atmosphere. And then B, to protect and preserve the marine environment in relation to climate impacts, including ocean warming, sea level rise, and ocean acidification. And I'll just finish this part by noting there were 18 public sittings held in September 2023, and submissions were received by about 40 state parties and international organizations. And I'll leave it at that. Penelope, you're muted.
Okay, thank you. Thank you very much, Sarah. Appreciate you doing that, and also within the time frame. So that was great. So we'll turn to you, Salvador. Tell us about the genesis of the advisory opinion before the Inter-American Court on Human Rights.
Well, okay, thank you very much, first of all, to our Human Rights Research and Education Center and the International Law Association Canada branch for organizing this webinar. Also, if I may have a warm hello to Chiara and Sarah, and it's a pleasure to be in this panel with you.
Yeah.
So
just before you go ahead, Salvador, we're having trouble hearing you. If you could just maybe get closer to your computer.
Yeah. Okay.
So, or speak up.
Better? Yes. Is this better?
A little better.
A little better. Okay. Maybe. Okay. So the advisory opinion 32 of 25 is titled Climate Emergency and Human Rights. So from the start, this is a human rights-based approach to the challenge of climate change. This is, by a landslide, the most significant advisory opinion that the court has ever adopted. This was a request made by Chile and Colombia in January of 2023, asking the court to identify or to advise on how to address the issues of climate change under a human rights perspective, with a specific focus on the differentiated impact that climate change has on island states, but also on vulnerable groups. So from the start, this is two of the main elements of the question of the submission filed by Chile and Mexico. The second point that is important here is that this is a record-breaking advisory opinion in the type of submissions that the court received. It was 263 briefings that the court got from 613 organizations, states, civil society organizations, universities, and individuals. As a disclaimer, our Human Rights Research and Education Center with the Human Rights Clinic at the Pontifícia Universidade Católica do Paraná from Brazil and the Universidad Internacional de Valencia from Spain, we submitted an amicus, or a written observation, not an amicus, to the court focusing on business and human rights, which I will talk later in the second part of this intervention. There were 4 public hearings in Barbados and Brazil during April and May of 2024, and the outcome, the resolution, the advisory opinion that was published in July 2025 is 219 pages long, plus approximately 170 pages of different individual opinions. The main laws that were used were, of course, the American Convention on Human Rights and the San Salvador Protocol on Economic, Social, and Cultural Rights, along with the Escazú Agreement on Environmental Justice and Participation, and of course, our UN Guiding Principles on Business and Human Rights. Just to respect the time, Penelope, I'm going to leave it here for now, and
great.
Looking forward to
okay.
The discussion.
Thank you so much, Salvador. All right, let's turn to you, Chiara. Can you talk to us about how the advisory opinion came before the International Court of Justice?
Yes, thank you, Penelope, and I reciprocate Salvador's pleasure at being in this panel with all of you. So for what the International Court of Justice advisory opinion is concerned, the Republic of Vanuatu led an initiative with a group of states which demanded the UN General Assembly to request an advisory opinion from the ICJ elaborating on states' obligations concerning climate change. So you might know that under Article 96 of the UN Charter, the General Assembly and the Security Council are authorized to request an advisory opinion from the International Court of Justice In this case, Vanuatu led the initiative that pushed the UNGA, the UN General Assembly, to request such an advisory opinion. Vanuatu, as you might know, is a country which is extremely vulnerable to the consequences of climate change, and this in part prompted this initiative, but in part it was also prompted by a strong youth movement, the Pacific Island Students Fighting Climate Change movement, which built regional support, lobbied the Pacific governments, they drafted the legal arguments, and they really framed this initiative in terms of intergenerational justice. It was also under this impetus that Vanuatu built this core group of states, which eventually resulted in 130 states supporting the draft resolution. And managed to engage CARICOM states, so Caribbean states, but also some African states, and of course Pacific states in this coalition that took some political steps, because eventually when it comes to triggering the process at the UN General Assembly, the steps are essentially political. Basically, a state or a group of states, as in this case led by Vanuatu, draft a resolution. They engage in consultations and negotiations. They try to rally consensus around the draft resolution, and then the resolution is tabled before the UN General Assembly, where it is generally adopted by simple majority. So Vanuatu sought consensus and obtained, was successful in obtaining such consensus, because the UN General Assembly Resolution 276 was adopted by consensus in 2023 and then communicated to the ICJ by the UN Secretary General on 12 April 2023. The request posed two major questions to the ICJ. One, it asked the court to clarify the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases. And the second part of the question was about the legal consequences under these obligations for states where they, by their acts or omissions, have caused significant harm to the climate system and other parts of the environment. And these legal consequences are framed both with respect to states and with respect to peoples and individuals belonging to future and present generations. Just a couple of words about the process. This was also an unprecedented process because it was the biggest in the history of the ICJ, drawing on an unprecedented 150 written statements submitted by states and international organizations.
Great, thank you so much, Chiara. All right, let's move on then and discuss some of the key parts of these respective decisions that have implications for business and human rights. So, what law did the courts determine was applicable, and what obligations do states have with respect to their own business-related conduct, and including state-owned enterprises, and also vis-a-vis private business actors? Let's start with you again, Sarah.
Great, thank you. So first off, I've already sort of hinted that in terms of what law did the tribunal determine was applicable, they did not engage explicitly with human rights. The applicable law to be engaged with is determined by Article 293 of the UN Convention on the Law of the Sea. And it notes that if the tribunal has jurisdiction, it shall apply this convention and any other relevant rules of international law not incompatible with UNCLOS. The decision itself talks about the importance of coordination and harmonization between the Law of the Sea Convention and external rules, and that this is important to clarify in order to inform the interpretation and to ensure that the convention is seen as a living instrument. And the tribunal also notes that where several norms bear on an issue, they should be interpreted as giving rise to a single set of compatible obligations, which I think is quite important. Also of importance is that COSIS did not ask the tribunal to consider the responsibility and liability. And so the tribunal does not engage with the secondary law of state responsibility. Instead, it confines itself to consideration of primary obligations. And so in that context, most of the decision is very clearly focused on the law of the Sea Convention, but there's reference made to many other bodies of law. Of course, much to the climate change regime, but also to the Montreal Protocol with regard to ozone, work of the International Maritime Organization, the International Civil Aviation Organization, the Convention on Biological Diversity, and a few others along the way. Importantly, the tribunal found that the Paris Agreement is not lex specialis, and therefore compliance with the climate regime is not sufficient for compliance with the UN Convention on the Law of the Sea. Also important, though, is that before engaging with the law, the tribunal considered climate science, and it reiterated that climate change has been understood since 1988 as a common concern of mankind, and then it relied extensively upon IPCC science, including and especially the role of the ocean in the climate system. And none of the science that was discussed and put forward was challenged by states. So from the 2023 Synthesis Report, the science says that climate change has caused substantial damages and increasingly irrecoverable losses, including in coastal and open ocean ecosystems, that the open ocean nutrient cycles are being perturbed. This is challenging management of fish stocks due to spatial distribution and abundance shifts. Sea level rise is an existential threats for some small islands and low-lying coasts, and also that ocean acidification has negative implications for marine ecosystems and species at risk, and large-scale, with implications for large-scale changes to the food web. So the court does, after discussing the science, say climate change is a threat to human well-being and planetary health, with vulnerable communities disproportionately affected. Human coastal communities are particularly exposed, and in this respect, climate change represents an existential threat and raises human rights concerns. So you would think that would be an opening to then engage more explicitly with international human rights law, but the unanimous opinion doesn't take that step. On the other hand, some of the declarations that were accompanying the opinion do refer to international human rights law and take note of submissions that were made by UN special rapporteurs with the Human Rights Council. So, for example, Judge Kidichisari takes note of these submissions, says that UNCLOS should be interpreted to integrate international human rights law and international environmental law, as a plain reading of the text would suggest this, and this is also in accordance with the Vienna Convention of the Law of Treaties. And then concludes that while ITLO sidesteps the need to construe Article 293 on applicable law to cover human rights when answering the questions before it, nevertheless, my impression is that in arriving at the conclusion on the nature of the obligations under UNCLOS and the answers, the tribunal has duly borne in mind human rights and been motivated by human rights. So the argument I would make is that despite the fact that there is no explicit reference to human rights, I would endorse the view that it is still nevertheless motivated by it in some way. So having made the claim that human rights are relevant and therefore business and human rights is relevant, what does this mean in terms of what obligations do states have? So again, drawing on IPCC science, the tribunal notes that deep, rapid, and sustained greenhouse gas emissions reductions reaching net zero CO2 reductions and including strong emissions reductions of other GHGs are necessary to limit warming to 1.5 degrees. Importantly, greenhouse gas emissions constitute pollution of the marine environment within the meaning of Article 114 of UNCLOS. And so the statement is made that anthropogenic greenhouse gas emissions are pollution of the marine environment and cause climate change and ocean acidification, which are deleterious effects. So I noted there were two questions. One, the first question related to obligations to prevent, reduce, and control pollution of the marine environment. And here the tribunal turns to Article 194 and notes that state parties have the specific obligations to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions, and to endeavor to harmonize their policies in this connection. So measures should be determined objectively. They should take into account the best science. The Paris and climate regime goals are relevant. They note that the necessary measures may vary in accordance with the means available to state parties and to their capabilities. And more explicitly, under Article 194, Paragraph 1, the obligation to take all necessary measures is characterized as one of due diligence. The standard of due diligence is stringent, given the high risks of serious and irreversible harm to the marine environment from such emissions. But again, implementation may vary according to states' capabilities and available resources. Under the same Article 194, Paragraph 2, there is reference to the jurisdictional scope, which is, of course, of particular relevance to business and human rights. So here it is noted that state parties have the specific obligation to take all necessary measures under their jurisdiction or control to ensure that the emissions under their jurisdiction or control do not cause damage by pollution to other states and their environment, and that pollution from such emissions under their jurisdiction or control does not spread beyond the areas where they exercise sovereign rights. So the obligation here is characterized as one arising in a transboundary setting, and so it is also an obligation of due diligence, but it's an even more stringent obligation of due diligence than under Paragraph 1 because of the nature of transboundary pollution. So I think there's a lot that can be unpacked from that in terms of how this characterization really moves beyond the sort of binary territorial, extraterritorial into a real focus on jurisdiction and control, transboundary harm. And that aligns with what we're seeing also in other recent statements, for example, from the Human Rights Council in a resolution on the ocean and human rights that talks about the ocean as a single biome. And so, again, it's sort of moving away from these boundaried language. I'll just say a couple of other things. First, that marine pollution from anthropogenic greenhouse gas emissions can be characterized according to the decision as coming from land-based sources, pollution from vessels, or pollution from the atmosphere. And so the convention has a lot more to say about exactly what is required in each of these, including the adoption of laws and regulations, the enforcement, the implementation of relevant international law rules, the need to ensure compliance, for example, of flag states. Also much on the need to cooperate, to assist developing states. And finally, under this question, the tribunal points to specific obligations of monitoring, reporting, and to conduct environmental impact assessments, which I think is, again, very, very relevant. So under Article 206, state parties have the specific obligation to conduct environmental impact assessments of any planned activity, other public or private, which may cause substantial pollution to the marine environment or significant and harmful changes thereto through anthropogenic greenhouse gas emissions, including cumulative effects. And such assessment shall be conducted by the state party under whose jurisdiction or control the planned activity will be undertaken, with a view to mitigating and adapting to the adverse effects of such emissions on the marine environment. For question 2, it turns to the obligation to protect and preserve the marine environment in relation to climate impacts, ocean warming, sea level rise, ocean acidification. Here, the tribunal focuses on Article 192, which has a broad scope, and a specific obligation is indeed found, but as well, where the marine environment has been degraded, this obligation under 192 may call for measures to restore marine habitats and ecosystems. This is an obligation, again, of due diligence with a stringent standard. And I think that gives some insights into sort of linkage with access to remedy and something that can be worked on in that context. A couple of just final quick points. There's also reference in the UN Convention and therefore by the tribunal to the specific obligations of states to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species and other forms of marine life. And reference here to the importance in this regard of the application of a precautionary approach, of an ecosystem approach, obligations to cooperate, and much of this extending to cooperation in the conservation and development, for example, of shared stocks or in relation to living marine resources. So I will stop there. There's a lot in here. And again, it's not explicitly framed in a business and human rights lens, but it seems very clear that this decision opens up the opportunity to think about climate change and business and human rights in an ocean-centered way.
Yeah, thank you very much, Sarah. That was really comprehensive. I appreciate it. Let's go to you, Salvador. If you could just set out some of the key parts of the decision before the Inter-American Court or the advisory opinion and the applicable law, etc.
Okay. First of all, can you hear me better now?
Yes.
Caroline, on l'a fait. Success.
Okay.
So my apologies. I had a problem with the microphone, but now hopefully everybody can hear me.
Much better.
So I would like to break down this in two sections. The contributions of the advisory opinion on substantive issues, and then to the specific elements on business and human rights that this advisory opinion has, which there is a lot. Just in advance, I would like to give a section, an advance. First of all, substantially, the court from the get-go goes and says and incorporates all climate change law under the scope of the American Convention on Human Rights. What this means is that for future cases regarding climate change or climate litigation, where we have seen around the world in the Americas, in Brazil, and in Colombia, if these cases were to get to the Inter-American system or to the Inter-American Court, climate change law will be the lens under which the state responsibility will be measured. This is, for those that are familiar with the Inter-American system, will understand that this is a common practice of the Inter-American human rights system of incorporating laws that are not expressing from the Inter-American system or the OAS, indigenous peoples' rights, just to name one example. So this is a first element that climate change is protected under the Inter-American system. The second thing, or the second point, is that the court recognizes two new specific rights. One, the right to a healthy climate. In addition to the healthy environment that was adopted in 2017's advisory opinion, the court recognizes expressly that there is a right to a healthy and sound climate. So, and the court goes on to develop what are the implications and elements of these rights. But thirdly, secondly, in this recognition of rights, the court recognizes that nature is a subject of rights. Now, there are decisions in Latin America, in Canada, and India, among other jurisdictions, that have recognized specific rights to rivers, to mountains, to ecosystems. So the court follows on this trend and recognizes this as a strategy to protect and recognize or how to address the climate change under a human rights perspective, going a bit beyond the Anthropocene. So also take into account what this means, especially for future generations. A third element here is that and here's something that we can discuss in the comments, that the court recognizes as a norm of use cogens, or cogens, how you pronounce your G, that the prohibition of creating irreversible damages for future generations is a use cogens norms. What does this mean? I have no idea. But we're just setting up the field work of how to address this. But underlying this, underneath all of this, there's an element that is just 3 or 4 paragraphs, but is important, especially for the business and human rights section, which is the right to science, the recognition of indigenous peoples' local knowledge and tradition, and the duty of the states to adopt policies and regulations based on empirical evidence. The court is definitely not apolitical. It takes into account the context where we're in, and this is a clear message to anti-science movements and climate change deniers, establishing a clear obligation that the right to science, whatever policy regulations you adopt, the court must fulfill states must fulfill based on empirical evidence. And the issue is specifically of business and human rights, and this, I think it is already one of the questions that were referred in the chat. The court has said for almost 6 or 7 years now that corporations are the primary responsibles in the protection of human rights. And the court has unequivocally said that corporations breach or are in the capacity to breach human rights if they do not fulfill the rights under the American Convention of Human Rights or local regulations. So it will be no surprise when the court pretty much has incorporated the entirety of the second pillar of the UN guiding principles to develop general frameworks on what a due diligence process should be and what are the responsibilities of businesses in their activities. In the case of this advisory opinion on climate emergency, the court says that the states and corporations have an enhanced due diligence obligation because of the nature of their business and the impact not only for the environment, but also thinking about future generations. And this is something that many commentators have not really picked up a lot, in the way that the court is not only speaking for a July 2025 audience, but they're thinking and talking to 20 years from now, 25 years from now. The importance to think long-term what decisions you make today can impact not only as legal poetry or a resolution on environmental law, but as a binding obligation and a threshold under which businesses and states might be held to account. What does this mean? In the case, what does this mean in enhanced due diligence? It means 3 things. First of all, that corporations have an obligation to share the information that they have before adopting an activity or carrying on a project that may have climate change implications. Secondly, that this should be periodically reviewed by not only by the state, but also by experts and civil society actors. Here, the element of indigenous knowledge and traditions for projects happening in indigenous lands has a relevant importance. And the third thing is the chain of production. The importance of a chain, cadena de valores, cadenas de producción, chain of production must be under the same scrutiny to address or prevent that the activity does not impact climate change or does not generate greenhouse emissions. To start concluding this part of this outlining of a 219-page decision, the court, and this is one of my favorite parts of the decision, and again, it's just 2 or 3 paragraphs long, is the court mentions international investment agreements. And the court here very subtly, in a very subtle way says, and I quote, that international investment agreements cannot be used to halt a state's ability to regulate and to protect the environment. For all those you international economic law scholars / nerds, you will see a reference to the Morocco-Nigeria free trade agreement that has never entered into force. The court does not really expand on this element, but it is clearly thinking about all this overwhelming amount of arbitration cases that are being presented before the ICSID because the states have actually cancel projects to protect biospheres, the biodiversity. Colombia, one of the state that submitted a report, is one of the most affected countries in this field. So the advisory opinion not only has specific sections on business and human rights, mostly focusing on states' duty to regulate, but also of businesses, pillars 1 and 2. But the court also, when talks about procedural rights, going back to Escazú Agreement, participation, transparency, and access to justice, the court mentions that corporations have a specific duty not to create obstacles in the access to information and participation of stakeholders or vulnerable groups that may be affected by their businesses, by their business activities. But in addition to that, the court says that corporations have a responsibility to protect human rights and environmental defenders. For those of you, and I see a lot of Latin American colleagues and Inter-American scholars in this webinar with us, to you will come this as no surprise, because the history of Latin America and in many of the cases of human rights defenders and environmental defenders and indigenous leaders that have been assassinated and have made it to the court are in relation, or there is a relation with protesting or opposing business extractive projects. So the court does not forget that. And although it does not mention this in an explicit way, sometimes, especially in advisory opinions, it's just as important as what the court says is what the court is not saying. And here, this silence is linking to other cases and to potential developments that we hope to see in years to come. Muchas gracias.
Yeah, thanks so much, Salvador. Very helpful. Let's turn to you, Chiara, for the ICJ decision.
Yes, thank you. So I will start from the law that the court determined was applicable. So the court confirmed that the applicable law in this case was, of course, the UN Framework Convention on Climate Change, the Paris Agreement, but also customary international law, international human rights law, and the law of state responsibility. The court also referred to the law of the sea, quoting the ILA's advisory opinion several times and also noting the important points of contact between the broad questions posed to the ICJ and those answered by the ILA's in its own advisory opinion. So basically, the court confirmed that climate obligations are not self-contained within the climate regime, but rather they interact with human rights and general international law. Now, an important finding of the court is that the Paris Agreement, including the 1.5 Celsius degree goal, are legally binding, and that states' obligations pertaining to the protection of the climate system are owed erga omnes because they are an interest of the international community as a whole. They protect an essential interest. So, and while not specifically naming any states, like the United States, the court said that countries that are not parties to the Paris Agreement still retain an obligation to protect the climate as a matter of human rights law and customary international law. And so when it comes to findings that are potentially, well, directly relevant, I would say, to business activities. So first of all, the court reaffirms that the well-established no harm rule, and it confirms that the duty of states to prevent significant transboundary environmental harm applies in the context of climate change. Now, in order to prevent such harm, they must ensure that activities within their jurisdiction or control respect the environment of other states and of areas beyond national jurisdiction. So this is definitely relevant to business activities. It is relevant also, if you will, to the protection of the ICs, areas beyond national jurisdiction. The court also confirms that the obligation that states retain is one of due diligence, And in the light of the scientific consensus, which indicates clearly that climate change is an existential threat, you see, this mirrors a little bit the language of the ILOs. The standard of due diligence for preventing significant harm to the climate system is stringent. So we are talking about a stringent due diligence standard. This is paragraph 138 of the opinion. This means in concrete that, first of all, nationally determined contributions under the Paris Agreement cannot be interpreted by states as box-ticking exercises. Of course, states retain some discretion in how they address their obligation to reduce greenhouse gas emissions and adapt to the impacts of climate change, but such discretion is limited. This is clearly stated by the court. States are obliged to exercise due diligence and ensure that their nationally determined contributions under the Paris Agreement, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5 degrees above pre-industrial levels. So discretion is limited in this respect. Actually, far from being a cosmetic exercise, a state NDC must represent its highest possible ambition in order to realize the objectives of the agreement. Now, the Paris Agreement also states that states parties must pursue domestic mitigation measures. And some states argue that this obligation under, this statement under Article 4 of the Paris Agreement is not a binding obligation. Well, the court disagrees with that. The ICJ states that this article creates a substantive obligation and that a particularly important aspect of that obligation is to adopt measures in relation to activities carried out by private actors. And the obligation to regulate the activities of private actors also recur when the court references international human rights law. It stresses that the regulation of the activities of private actors is one of the means to address the adverse effects on climate change on the enjoyment of human rights. Now, if regulating private actors is part of a state's due diligence obligations, then a failure to exercise regulatory due diligence may constitute an internationally wrongful act. The court gives the example of a state's failure to adopt the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. So it is clear that failing to regulate business actors to protect the climate system might constitute a breach of international law and trigger a panoply of consequences under the law of state responsibility, as the court says. So states might be responsible for the breach of specific due diligence obligations. In some cases, the conduct of a corporation might be directly attributable to the state. These are those cases in which we fall under the general rule of attribution under customary international law, according to which the conduct of any organ of a state must be regarded as an act of that state. Well, this means that if a state-owned enterprise qualifies as a state organ under international law, then its conduct, including high-emitting fossil fuel production or related activities, is directly attributable to the state. Now, the state might potentially be in breach of its obligations, the court says, also when one of its organs grants fossil fuel exploration licenses or the provision of fossil fuel subsidies when these actions run counter the due diligence obligation to protect the climate system. So for states, the bigger picture implies not only a duty to regulate private actors, but also more generally to reconsider their energy policies as a whole. And to me, the reference to fossil fuel exploration licenses is particularly interesting because it indicates that the state's support for projects aimed at expanding fossil fuel production could be incompatible with states' obligations under international law. Importantly, the court's opinion sanctions the importance of science, as also we have seen in the other two advisory opinions, in particular attribution science, which much importance has also had in litigation against states and corporations at the domestic level. And the ICJ stresses that while climate change is caused by cumulative GHG emissions, it is scientifically possible to determine each state's total contribution to global emissions. Also, the rules of state responsibility under customary international law can address a situation in which there are multiple responsible states. Simply put, multiple actors contributing to the harm does not bar a finding of responsibility, and this is supported by both legal and scientific arguments. I believe I'm out of time. Is
No,
that
you have
correct?
2 minutes.
Then I will continue for
Okay.
2 minutes. First of all, like just two final points. One is that, of course, the due diligence standard is inherently adaptable. So the principle of common but differentiated responsibilities and respective capabilities is stressed by the court. Once again, it will determine the standard to be applied when assessing, for instance, the adequacy of NDCs. So the countries which are most responsible for their historical contributions to cumulative greenhouse gas emissions should also be held to a higher standard of due diligence. And this, of course, also includes strict regulation or stringent regulation of business activities. And finally, well, I've already said a little bit that states' obligations pertaining to the protection of the climate system, according to the court, are obligations owed erga omnes. Indeed, they protect an essential interest of all states in the safeguarding of the climate system, and therefore all states or all states parties of the Paris Agreement, in the case of the Paris Agreement, have an interest in compliance, which enables all states to invoke the responsibility of other states for failing to fulfill these obligations through, for instance, diplomatic means, but potentially even through contentious litigation before the court itself. This might enhance pressure on states to act effectively on addressing climate change, including through the regulation of business activities. Thank you.
Oh, grazie mille, Chiara. Thank you so much. Thank you. We have one more round of questions, and so I wondered if you could each please just share your thoughts briefly on the impacts of these respective cases individually and collectively for the business and human rights normative framework. So we'll start again with Sarah.
Great, thank you. I think there are a few thoughts to share. First, as I've argued, I think it is very important to see the ILA's decision also as a human rights decision, or to see it as part of a collective conversation in which human rights is clearly a part of that conversation. And so each of the other decisions does make reference to the ILA's decision, but I think it's important not just to look at the law of the sea aspects within the other decisions, but also to sort of delve into what the ILA's decision itself provides. So in terms of sort of where this might go, I think there is the possibility that there will be some contentious claims brought through ILO. Certainly the door is opened with this, and I note that in this advisory opinion there was no reference to state responsibility, and so that might be something that we will see, which would again have implications for business and human rights. Also, I think there's much in this decision that we are likely to see or could be used in climate-related litigation in the business and human rights context. And so there's a lot of material there that can be drawn upon. I think as I noted in this case, and the others have also noted, there are a lot of sort of jurisdictional implications for business and human rights that come out of these decisions. Very clearly, reference to jurisdiction and control, transboundary harms, not taking a, territorially bounded understanding of climate obligations, and the climate ocean conversation is another important piece. And one more that I think is important is how the right to a healthy environment, or the right to a safe climate, how the human rights and environment conversation is portrayed in the other two decisions, I think, is also part of a conversation with how to bring the ocean into the human rights and environment space. And by this, I note the ICJ, of course, endorses or recognizes the right to a clean, healthy, and sustainable environment as being an essential part of, or essential for the realization of other human rights. In the Inter-American system, we have not just reference to the right to a safe climate and to the rights of nature, but also the characterization of the right to a healthy environment as an autonomous right, which respects nature in and of itself. That to me resonates very much with, in particular, the second question in the ITLOS decision, which, as you might recall, is about protecting and restoring the marine environment and arguably includes requiring an obligation for states to take measures to restore the environment, the marine environment. So if that is put together with this idea of a human right to a healthy environment as an autonomous right, I think there's again some really interesting possibilities for better grounding harm to the marine environment as a central piece of a business and human rights conversation. And then the last point I'd make is the ITLOS does talk in one paragraph about geoengineering. I don't think any of the other decisions do. And in the context of ITLOS, there is a specific provision in Article 195 that says that requires states in taking measures to prevent, reduce, and control pollution of the marine environment, not to transfer directly or indirectly damage or hazards from one area to another, or transform one type of pollution into another. And that is a really interesting and important provision for trying to turn our minds to what does it mean for states to take due diligence in a context where the Paris Agreement, for example, provides for essentially some version of, anyway, for the whole carbon dioxide removal, carbon credits, how do we, carbon markets, how does all of that play out? And what does that mean for the emergence of new technologies? And that I think, again, is a big business and human rights conversation that we just see like a tiny scratch at the surface of that in ITLOS, and I don't think it's in the other two, but I think it's a huge business and human rights issue to come. I'll stop there.
Thanks very much, Sarah. Salvador.
Yes, I think, first of all, contextually, the court is following a tradition where its advisory opinions have more nuance and theoretical developments than most of its contentious cases. Even though it is an advisory opinion, it doesn't mean that it lacks teeth. And if we observe other advisory opinions from the past, like, for example, the advisory opinion on gender identity or an advisory opinion on the rights of children, we will see that these advisory opinions have the possibility to change laws, policies, and even government infrastructure as a whole, right? The advisory opinion on the environment and human rights from 2017 is pretty much the Escazú Agreement that was adopted a few years afterwards. So contextually, it is important for us to understand the power and influence that this advisory opinion might have as a standalone opinion. Secondly, the impact of moving forward, there are many challenges. First of all, what does this mean for climate change litigation and the exhaustion of local remedies by, let's say, the cases of children in different forums in the European Union, but in the Latin American context, the most important case would be the Colombian case of children litigating before the Constitutional Court issues on climate change. So what would that mean from a standing point of view, reparations, participation, so on and so forth? So I think that the declaration of these rights is just a stepping stone towards what does this mean for effective litigation. Secondly, and it goes a bit in the same line, is related to the recognition of rights of nature. And if you read the 170 pages of the individual opinions, you will see that this is one of the biggest point of contention. And this recognition was adopted by a slim majority in a context where the current composition of the Inter-American Court is more on the conservative side. But regardless of the local politics of the courts and of the system, one thing is to declare a right, but what does this mean for businesses? If you recognize that a river is a subject of right, or a mountain, or a biosphere, what does it mean effectively? What are the specific obligations and duties of states, but also of businesses? What does due diligence mean when you recognize that a river is a collective subject of rights? It means a no-going zone. Does this mean that you can operate, but if you have the consent or agreement of local communities? There's a lot to be decided and to be discussed that only through litigation we will see how this actually plays out. But here the important thing is, and it's a cautionary tale, that the declaring or recognition of a right is just the basement, not the ceiling of what this means to actually make it enforceable and to help people accountable. And the third element is we will see how the element of climate change as a right, or the right to a healthy climate as a right protected in the American Convention of Human Rights means in practice. For example, there is currently a case in the docket of the court, which is called the Mashcopiro versus Peru. I'll write the name in the chat, which is precisely a case where the issue of healthy climate can come into play, in addition to different elements of business and human rights, like, for example, the privatization of security services that are or supposedly supposed to be fulfilled by government officials or public officials. So all of these elements are only coming to play, and we will see in the next few years how the court develops some of these ideas adopted in this advisory opinion.
Thank you, Salvador. Over to you, Chiara. Thank you.
Yes, thank you. I think one important finding that emerged from the ICJ advisory opinion, but also from the ITLOS advisory opinion, and to some extent from I would say also from the Inter-American Court of Human Rights advisory opinion, is the fact that indeed states have stringent regulatory duties towards corporations. The ICJ makes clear that private actors must be regulated, and that failure to do so might lead to international responsibility. Now, the question is whether this can be relevant and have implications for domestic litigation. I believe it does, for sure. For instance, it has implications for domestic litigation against states for failing to regulate corporate emissions ambitiously enough. Of course, there are already examples of such lawsuits, some of which have also been successful, but the ICJ opinion and potentially the other advisory opinions as well provide additional authoritative support in this respect. Actually, we already have an example of that in the Bonaire climate case. This was brought by Greenpeace and residents of the Caribbean island Bonaire against the Dutch state. And during the oral pleadings, both sides actually referred to the ICJ's advisory opinion, and the 2026 judgment relied on such opinion as for authoritative interpretive guidance. The Dutch court eventually found that the Netherlands had violated human rights by failing to adequately protect Bonaire residents from climate impacts and ordered more ambitious mitigation and adaptation measures. And in this case, indeed, the weight of the ICJ's advisory opinion was already felt. If we consider litigation against corporations as well, you might recall that the Milieu Defensie versus Shell climate case in the Netherlands failed on appeal because the Dutch court held that it lacked a sufficiently clear legal standard to impose a specific emissions reduction obligation directly on an individual company. in a sense, that highlights a regulatory gap at the state level, and the ICJ is now clarifying that states must legislate effectively in this respect in relation to private sector emissions. So these developments might make future climate cases more successful, also those that are brought against corporations. And finally, together with the other two advisory opinions, the ICJ opinion increases indirect pressure on fossil fuel companies by raising expectations of climate due diligence. In this context, the EU's weakening of climate transition plan requirements in the Corporate Sustainability Due Diligence Directive looks like a missed opportunity and very short-sighted. This was indeed an opportunity to guide companies clearly in their climate due diligence efforts, and also it was a way to help member states comply with their international obligations, because it is now clear that failing to adequately regulate companies in relation to greenhouse gas emissions can lead to international responsibility. I would invite everyone to read the paragraph 456 of the ICJ's advisory opinion, which confirms that the questions posed by the General Assembly represent more than a legal problem, but they concern an existential problem, and international law, according to the court, has an important role, but ultimately a limited role, because what is needed is human will and wisdom, including on the political level. These are words of the court. And the court says that it hopes that its conclusions will allow the law to inform and guide social and political action to address the ongoing climate crisis. So it is really a call on the political power to play its own part, which is the primary role, I would say, in addressing this crisis.
Thank you very much, Chiara. All right, we have about just under 20 minutes for some questions, and we've got some questions that are 4 questions that are in the question and answer. I'm going to read them out, and then you can decide if you want to address them. So Rahul Singh asks, how do these advisory opinions interact with the UN guiding principles on business and human rights, and particularly Pillar 2, the corporate responsibility to respect human rights? I think some of your presentations have addressed that, but maybe if you could each just say something short about that issue. Go ahead. Who wants to start?
If you want, I can say something about that.
Yeah, that'd be great.
The UN guiding principles on business and human rights are not explicitly referenced in the ICJ's advisory opinion, but of course, I mean, the advisory opinion contributes to clarifying even further Pillar 1 of the UNGPs, clearly. So the whole issue about states' obligations, and it is increasingly clear that Pillar 1 is not only about international human rights law, but it's really about international human rights law in the context of other international obligations of the state, climate change, environmental law obligations, and so on. As concerns Pillar 2, perhaps here the Inter-American Court advisory opinion is more interesting, but for sure the advisory opinion of the ICJ increases pressure on states to adopt legislations of the type of the due diligence laws that have already been adopted in some European countries, but that are also being discussed in some Asian countries, for instance. I think that the case can be made even stronger than before, that states need to have in place this kind of legislation, and that contrary to what the European Union is doing with its own directive, these laws must have a clear climate change dimension. For instance, this is the case for the French law on the duty of vigilance, but not for others.
Thank you very much, Chiara. Sarah, did you want to have a quick word, and then the next question's for Salvador? That's perfect.
Yeah, just a super quick word to say that, of course, the ILA's decision doesn't refer to human rights at all, and therefore, or doesn't, aside from one sentence and the reflections of the accompanying declarations. But I think it nevertheless has something quite important to offer for Pillar 2, which is by turning attention to the marine environment and turning attention to the obligations of states in relation to shipping, for example, and other actors that are, business-related actors or business-owned actors within the marine environment. It really opens the door for a conversation about Pillar 2 in relation to business in the marine environment context. And I know that's something that, again, we're starting to see through the some reports of special rapporteurs of the Human Rights Council, including one from 2023 by the Special Rapporteur on Toxic Substances and Human Rights, which is actually specifically on shipping and human rights, and I think is quite relevant for that conversation.
Great. Thank you for that insight, Sarah. Appreciate that. The next question is for Salvador specifically. Andrea Luke from Lima, I believe. Hello. She said, if I understood well, business has obligations related to human rights as particular actors, but we need states' participation in order to supervise that. How do we promote the supervision if a state doesn't have a due diligence law, a mandatory law? Is it possible to have a different way to implement those particular actors' obligations?
Muchas gracias, Andrea. Hola, Andrea, ¿cómo estás? Mucho gusto saludarte. Manda sol, por favor, que aquí está haciendo bastante frío, ¿ok? Pero back to your question, I think that, yes, for sure, the court focus on state responsibilities. And the court's opinions are always, and decisions are always focused on what a state should and should not do. And as you know well, Andrea, the article breach within the American Convention of Human Rights has always been Article 1.1 of the treaty, which establishes a state's duty to adopt the necessary laws and policies to the fulfillment or to fulfill the rights recognized within the treaty. So the court, I think, that has seen that more and more the business and human rights agenda, at least within the Latin America and the inter-American sphere, the states have failed to adopt meaningful legislation on business and human rights, right? And if you see when almost 10 years ago, there was the heyday of the national action plans on business and human rights, and that went to nothing. That went nowhere. Okay, let's be real here. And it was just a waste of time and efforts without any form of meaningful change. And Andrea, you're Peruvian just like myself. How can you have a national action plan on business and human rights without specifically adopting or recommending changes on legislation regarding due diligence, responsibility of businesses? So if you're ignoring the main issue or one of the main contributions of the UN Guiding Principles, you're falling short. However, the court then does speak to businesses because we have seen in Latin America, right, how business corporations and business associations are actually taking the lead on incorporating these due diligence processes, but under their terms, right? And they're using whether it's the OECD guidelines or other soft law governance instruments that Professor Simons has presented in her case, in her book, The Governance Gap, quite well. But these are elements that they're using. You know what? We are going to take care of this, but under our terms and conditions. And what the court is trying to say is, okay, we cannot impede that, but there is a human right obligation here. So that's why when the court says businesses are the primary responsibles of respecting the human rights and that businesses breach, not create adverse impact, not create negative impact on human rights, the court is speaking clearly that there are elements of accountability. So it is not a chicken and egg situation because you already have legal institutions in tort, responsabilidad civil extracontractual, to actually hold or try to hold these corporations accountable.
Gracias, Salvador. Okay, so the next question is from Julia Gonçalves. Sorry if I didn't pronounce your name correctly, but she said, thanks you all for your excellent presentations and wonders whether there are specific obligations regarding women's rights in each of these decisions, and do you think there's an intersectional approach? So I don't know who wants to answer that. Chiara?
I can say something about the ICJ's advisory opinion. The standards of protection of women's rights under international human rights law are definitely mentioned by the court. Of course, the CEDAW is mentioned, but also the work of the committee of the CEDAW. And the court recognizes that the IPCC science also confirms the specific impacts of climate change on women and on indigenous peoples, for instance, so recognizing the fact that there are differentiated impacts of climate change on different groups. I think it has implications for intersectional protection of human rights, in that it confirms that states' obligations in relation to climate change derive from a plethora of international law instruments, including the whole panoply of human rights treaties that protect the rights of specific groups and of women as well, as explicitly stated in the advisory opinion. So definitely there is a good basis there to argue both in advocacy, in policy making, and potentially in litigation that the specific impacts on women's rights of climate change should be considered in state policy. Yeah.
Thank you, Chiara. Sarah?
Just to add briefly, by chance, I wrote a paper actually on women and the marine environment, which I published a year or so ago, which sort of explores where it's found and not. And of course, the ILA's decision doesn't refer to humans, therefore there's no consideration of different groups. But it's important to note that, for example, the recently adopted BBNJ agreement does, for the first time, include some consideration of the rights of women, and separately and differently rights of Indigenous peoples and local communities. So it's not an intersectional explicit incorporation in the treaty. I think the guidance for the intersectional thinking about these issues in the marine environment and climate marine environment context is again going to come and is coming through reports and resolutions of the Human Rights Council in the last year or so, where much more attention has gone to human rights in ocean and marine environmental protection in that context. And I think we can see there a lot of reference to intersectional approaches.
Thank you, Sarah. Salvador?
Oi, Julia, tudo bem? Obrigado pela pergunta por estar aqui. And so, as you know, Julia, in the Inter-American Court's advisory opinion, there are specific sections regarding the rights of women and how women are disproportionately affected by the impact of climate change. However, and as you know this better than I do, it is very parochial and condescending section. And it's perhaps the weakest section of the advisory opinion. Because just to build on what Sarah was speaking, there's one thing is to talk about intersectionality, but at one point you really mean this and you want to assess the disproportionate effect that climate change has on an Indigenous woman or a woman living in poverty, and then just saying that they are disproportionately affected and the state should do something about it. So in a way, I think having a rich tradition and practice in the recognition of women's rights and having a Belém do Pará Convention as a founding and leading instrument within the inter-American system, the section on women falls flat, and it almost reads like, poor women, they're vulnerable, the states must do something about it. But what does that mean? Well, is it the same for a woman in Belize than an Indigenous woman in the Amazon in Brazil? What does it mean for access to participation, justice, so on and so forth? So I think that as important recognition without going to the depths of what this means for people's lives, having 319 submissions, it's a big mistake or a big fault of the court.
Thank you, Salvador. The next question is from Kaima George Chuka, who's a PhD student at the University of Ottawa. Hi, Kaima. Another question for Salvador. In practice, are business and human rights obligations being meaningfully upheld? Could you share concrete examples of the mechanisms through which this occurs? And for Chiara, are there illustrative cases where the law of attribution has been successfully applied to a state, resulting in enforceable consequences?
Okay, well, thank you, Kaima. Very nice to meet you. I would just wanted to say, I'm just going to build on my first response regarding the scope of due diligence regulations on this, but I would say no, they're not respected. Okay, but secondly, I would add that at this point, it is through litigation that these small victories are coming along. And whether there are cases on Ecuador, whether there are cases also at the national level in Colombia, using torts is a field that is yet to be explored. And because when you use torts within the civil law tradition in Latin America, you have access to reparations. If you just focus on constitutional recourses like tutela, amparo, recurso de protección, you may have a recognition of a violation or a breach of a right, but not necessarily not reparations. So what is it good if you're thinking from a victim's perspective? What's the good of having, oh, your right to safe environment was breached, but no compensation for the business accountable to actually pay. So I think that this is a field, at least in Latin America, with civil law traditions, it is a field that needs to be explored further.
Thanks, Salvador. Over to you, Chiara.
Yes, so if you are referring about attributing the conduct of a corporation to a state, not to my knowledge. This would have to be demonstrated by by reference to the applicable law, and indeed you have to basically demonstrate that the corporation is not enough to be state-owned. So it's not enough for a corporation to be a state-owned enterprise, but it must be shown that it qualifies as a state organ. And for instance, the entity could be legally integrated into the state structure within, I don't know, the legislative or the executive power. And so it's not enough to be owned, but it must be part of the state apparatus. It could be also an entity exercising governmental authority, and then attribution depends on exercising public authority and not just a commercial activity of a purely commercial character. You could try and demonstrate that the company acts on instructions of or under the direction or effective control of the state. And this requires indeed factual control over the conduct in question that should be attributed to the state. As you can imagine, this is a bit the situation in which the conduct of a company is attributable to the state is a sort of a marginal situation, I would say. In the vast majority of cases, this will not be the case. And potentially the most promising avenue is to look at due diligence obligations of the state, obligations to regulate the activities of the corporate actors. So holding the state accountable for failing to take those acts that are required under international law, under the applicable law in terms of due diligence obligations. Attributing the conduct of a corporation to a state as such is extremely more difficult.
Okay, thank you very much, Chiara. Okay, this is looks like probably the last question we'll have time for. So from Rosalie Schmidtli it says, you mentioned the right to science. Does the advisory opinion, and I'm assuming we could each speak to this, say something about how states could handle conflicting climate science that is presented? Does anybody want to start on that? Sarah?
I'll start. Of course, the International Tribunal for the Law of the Sea very explicitly endorses the science that's coming from the IPCC, and it doesn't itself talk about the right to science. But I will say that I've been thinking about the right to science in the context of the questions that arise over geoengineering or carbon dioxide removal technologies. And this isn't really an answer to your question, except to know that under the Law of the Sea Convention, I noted that there was this article about, taking measures, making sure that one isn't transferring pollution from one or transforming one type of pollution into another. But there's another provision there that talks about the importance of states, taking measures to prevent the use of technologies, without having measures taken to prevent, reduce, and control marine pollution. So I think the science questions, I guess what I'm trying to say is the right to science questions and conflicting science is going to be important, not just in relation to climate science, but in relation to the science that needs to be done in order to assess technologies that may be being put forward to address the climate problem. And so that's just another area that we're going to need to think about.
Thank you. So is anybody else burning to answer that? Because if not, I'd like to move on. Salvador, you wanted to say something?
Yeah,
Okay.
just because the court does have a specific section on the right to science, basically the court does not mention about conflict of science because the court, just like ITLOS, it vindicates the role of the IPCC and the work of the IPCC. So that's, again, a political element in another legal advisory opinion. It does not mention about conflicting science, but it does use the latest available empirical science or knowledge to actually inform policymaking, so that the court is just setting the foundations for many discussions like the one that Sarah was mentioning. Thank you.
Okay. So I guess we have just 4 minutes, and I know Chiara has to catch a train, so I want to make sure that we finish on time. But maybe we could, each speaker could just have, if you have a final thought you want to add, 30 seconds to 1 minute maximum, go ahead. Who wants to? Sarah.
I can just say briefly, I think the key messaging is do think of the ITLOS decision as a human rights decision, even if there is very brief passing reference made to human rights. This is very relevant to the business and human rights conversation, and the importance of integrating ocean into climate thinking is crucial, and this is a great decision to help with that process.
Thanks, Sarah. Salvador?
Yeah, I would like to end with an invitation. As you know, the African Court on People and Human and People's Rights have an upcoming advisory opinion on climate change that was brought by the Pan-African Lawyers Union. The deadline to submit requests is March 31st, and on the field of business human rights, there are specific questions related to due diligence and the due diligence, duty of care, and the rights of indigenous peoples. So there are gaps in all of these decisions that maybe the African Court can take a lead on this. So I would invite everybody to consider participating.
Thanks, Salvador. Chiara?
Yes, I would say I'm also looking with much interest at the African system, where also a study has been commissioned on climate change, in which there's a so-called zero draft of this study, examining the responsibilities of corporations under the African Charter of Peoples and Human Rights. So not only the obligations of states, but also of corporations, because as you might know, that charter recognizes the duties of the individual, unlike other human rights treaties. So there are some very interesting ideas that come up of that study in relation to the climate due diligence obligations of corporations. And personally, I'm very curious to see how these 3 advisory opinions and plus the upcoming the upcoming work from the African system will play out in facilitating advocacy at the domestic level, at the transnational level, and potentially also bringing about some more successful cases of climate change litigation against individual states and corporations as a means to put pressure, especially on policymakers, to finally play their part and adopt effective regulation of business activities in line with their own international obligations.
Thank you, Chiara. Over to you, Una.
Thank you so much. Merci beaucoup, Penelope. On behalf of the Human Rights Research and Education Centre, the International Law Association of Canada, and everyone on this webinar, I'd like to thank Penelope Simons, Sarah Seck, Salvador Herencia Carrasco, and Chiara Macchi for providing so much amazing information today. I'd also really like to thank Viviana Fernandez and Carol Faucher for their contributions in making this event possible. Je remercie aussi l'auditoire de votre attention et de vos questions approfondies. Veuillez suivre le CREDP et l'ILA Canada sur nos sites web et médias sociaux respectifs pour nos prochains événements. I wish everyone a wonderful rest of the day. We have lots to think about after this. Je vous souhaite à tous un excellent reste de la journée. Thank you.
Thanks so
Merci.
much. Thanks, everyone. Thanks.